Hello everyone, this is Tom Fox and I'd like to welcome you to episode 134 of the FCPA Compliance and Ethics Report. Today it is my distinct privilege to have back my good friend and colleague, the FCPA professor, Mike Kaler. In this episode, it's a continuation of our earlier episode, but we focus on some remarks by Judge Rakoff, Judge Leon, individual prosecutions under the FCPA, and the use of deferred prosecution agreements under the FCPA. Well, we both agree that some very interesting remarks were made by judges in both public and court documents, and we want to explore those. The episode comes in just over 20 minutes. I hope you enjoy it. Thank you very much for listening. Hello everyone, this is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today I have back for the first time in 2015 the FCPA professor, Mike Kaler, a longtime fan of the professor and occasional guest of the podcast. So Happy New Year and welcome back, Professor.
Thanks for having me back, Tom.
Really looking forward to hearing about some of your observations from the FCPA year past and what you might see in your crystal ball of the FCPA year going forward. So let me just start off, jump right into it with the following. 2014 was the second highest gross amount of FCPA fines ever, but that's just one number. What does that number tell you or not tell you?
Well, I hate to disagree with you from the get-go, Tom, but just because one blog out there may say that the BAE enforcement action is an FCPA enforcement action, notwithstanding the fact that BAE was not charged with any FCPA violations. 2014 was actually the largest year in FCPA enforcement actions. The DOJ and SEC collectively brought in $1.6 million, which is the largest of all time.
Billion,
yeah, I'm sorry. The B word.
The B word. So,
but to your second point, that doesn't tell you much of anything. I know there's a lot of FCPA Inc. market participants that are marketing that number, but let's face it, 70% of that number is just two enforcement actions. The Alstom enforcement action, which was $772 million, and the Alcoa enforcement action, which was $384 million. I like FCPA statistics just as much as the next person does, but anytime you have arbitrary cutoffs, i.e. a year, it's pretty meaningless. You know, for instance, if the Alstom enforcement action took place 10 days later, or the Alcoa enforcement action took place 10 days sooner, the numbers would be materially different from 2004.
Well,
I think the most accurate way to view FCPA enforcement statistics is by looking at the number of unique instances that give rise to FCPA enforcement actions. So in 2014, using the core approach, an approach that even the Department of Justice endorses to tracking FCPA enforcement statistics, there were 10 enforcement actions. And this was the second lowest number in the last 7 years.
So it is interesting that Alcoa and Alstom really bookended the year, one the first week of, I think, January 2014, and then Alstom coming in certainly before Christmas, but maybe even the week before Christmas of 2014 as well. Do these, Alstom was the largest DOJ criminal fine, as I recall, but do these large numbers give you any insight or tell us anything about FCPA enforcement going forward, or are they just anomalies that happen to fall the first week and the next to the third week of the year?
Well, the Alstom action needed to be resolved so that Alstom's acquisition by General Electric could go forward. That's well known. But to your more substantive question, every FCPA enforcement action is unique, and the ultimate fine and penalty amount is based upon the conduct at issue. So while I agree that FCPA settlement amounts appear to be increasing for no other reason than they're just increasing, you know, at the end of the day, a settlement amount is based upon the conduct at issue. And the reason the Alstom enforcement action was as high as it was has to do with, as the DOJ indicated, And as the settlement documents make clear, not just the conduct at issue, but how Alstom historically responded to that conduct and whether it cooperated in the DOJ investigation. So I know a lot of people like just to look at these numbers, but the numbers in and of themselves are really not that meaningful. And let's not forget, FCPA enforcement in 2014 saw a number of what I'll call, garden variety, sort of nuts and bolts enforcement actions. So while Alstom and Alcoa were big cases, you had some very small cases, as well. Bruker Corporation, a travel and entertainment case. There were several travel and entertainment cases from 2014. So you saw the big, and then you saw the small as well. It's really across a broad spectrum, and I think that is a more meaningful way to look at enforcement from 2014 than just the aggregate numbers.
We both blog. We try to blog certainly, if not every day, a large number of days, but we both come at it from a different perspective. I come at it, I try to get some lessons learned from the compliance practitioner, and although you do provide that, really your focus is the law. Is there anything, any trends you saw from 2014 about the law that either intrigued you, scared you, elated you, or in any other way moved you?
Well, there were a number of instances from 2014 that I think should cause people to take notice. For instance, the SEC resolved approximately 85% of its enforcement actions in 2014 in the FCPA context through its administrative route. I think that's a very troubling trend to anyone who values transparency and independence and having a division of responsibility between judge, jury, and prosecutor. But that was certainly a notable development that we started to see bubbling, if you will, in 2013 that clearly manifested itself in 2014. And, the end result of that is while there was very little judicial scrutiny of FCPA enforcement to begin with, given the SEC's more frequent use and its commitment to continue to use this resolution route, there's virtually no judicial scrutiny of SEC enforcement. 2014 obviously saw the 11th Circuit decision in Esquinanza, and I know that decision may not have come to a surprise to a lot of people. The fact of the matter is, this was the first decision of precedent as to a key element of the FCPA's anti-bribery violations in the 38-year history of the statute. So, you can really account the number of substantive appellate court decisions in the FCPA context on one hand and still have a few fingers left over. So almost by definition, from the law standpoint, the Esquinanza decision out of the 11th Circuit in May has to really be the top law item of the year.
What about the two opinion releases? Anything in either 1401 or 1402 that intrigued you from the FCPA professor legal perspective?
Well, again, DOJ opinion procedure releases are not law, but it's a form of guidance as to the DOJ's view of the statute. And just to remind viewers what these opinion releases were, the most recent one concerned a merger issue. And from my perspective, much of what has been written about FCPA risk and M&A transactions has been getting a fundamental point wrong. And that is, just because a company subject to the FCPA acquires another company that prior to the acquisition was not subject to the FCPA, that acquisition in and of itself does not create FCPA liability where none existed pre-acquisition. The DOJ, to its credit, recognized that basic fundamental principle, and that's sort of the takeaway point from that opinion procedure release. It's really unobjectionable from my opinion. Now, I'm not saying there's no FCPA risk in M&A transactions. Clearly, post-acquisition, there's a lot of risk because now that entity that may have been violating the FCPA is now part of the acquiring company's hierarchy. But that was one of the opinion procedure releases. And the other one, I think was just evidence of how skittish sometimes companies are when it comes to FCPA risk, because the one other opinion procedure release from 2014 concerned a company purchasing at fair market value a former business partner's interest in a corporate entity, and that former business partner had subsequently become a foreign official.
I guess that's the one that intrigued me because I would have really opined the other way because I read it to be a change in a buyout for someone simply because they became a foreign government official, but with, I thought, very creative lawyering by whoever the relator's parties were involved, they were able to persuade the DOJ that it was not an actual course of events or course of actions. But so did you read that differently? It didn't surprise you, the outcome?
No, it didn't surprise me. And, I've read every opinion procedure release there is, as I'm sure you have as well. And I think there's the following point I think can be made. And, as the father of small kids, I use parenting analogies a lot. But I view these opinion procedure releases as sort of the following. A kid can ask their mom and dad to do something, and mom and dad will say yes because they were put on notice of it and were informed about it before it occurred. But gosh forbid if mom and dad find out about it after the fact and weren't apprised of it, there could be a different outcome. So I think as perhaps non-relevant as that analogy may be, I think there's a lot to be said for that in the FCPA opinion procedure context, where if a company proactively, which is what the procedure release program is for, apprises the DOJ as to something, I think there's some reasonableness there that might not be there if, for whatever reason, the DOJ may have found out about it after the fact. Now, you look at opinion procedure releases, I think 99% of them, the DOJ clears the conduct at issue. But that's because there's this well-known, at least in the industry, FCPA Mulligan rule, where the party can pull the opinion procedure release if they think they're going to get a bad opinion. And practitioners have told me that frequently happens, so it's not surprising that you see 99% or so of opinion procedure releases get the green light.
I wish someone had told me that. That sure sounds like a great blog post, the Mulligan rule.
Tom, you said you read me. Google FCPA professor, the Mulligan rule. I talked about that, I think it was probably 3-4 years ago.
No, I like your analogy. The way I phrase it is, as a teenage boy, I often engaged in actions and would ask for forgiveness after the fact. As the father of a teenage daughter, my views have modified somewhat, that I would much prefer to be asked for permission beforehand.
Exactly, and I think there's, at the end of the day, these opinion procedure releases are not cranked out by computers. They're cranked out by real people with, real feelings and real needs to feel respected, I guess you could say.
We had, interestingly, the Department of Justice really seemed to go back on the speaker circuit, particularly in the second half of the year. They had not really gone outside of Washington, D.C. to give talks. And, for instance, we had Leslie Caldwell speak at a couple of events. We certainly had some other speakers. One of the things I noted from Leslie Caldwell's speech to the ECOA was a direct reference to not only prosecuting more individuals, but actually asking corporations to tee up individuals in their internal investigations. Did you read that into her speech, or did you see anything different about individual prosecutions in any of those sort of remarks that we heard on the speaker circuit?
You're right. Every fall, it seems, the DOJ and SEC officials go on the speaker circuit and help private for-profit companies get people in their seats, which I think is wrong, but that's not the question you were asking me. The DOJ and SEC's rhetoric as to individual prosecutions, I think, was once again empty in 2014. The fact of the matter is since 2008, 75% of DOJ corporate actions have not resulted in any related enforcement actions against individuals. And on the SEC side, interestingly enough, the number is worse, which is sort of counterintuitive given that the SEC as a civil law enforcement agency has a lower burden of proof. Since 2008, 85% of SEC corporate actions have not resulted in any individual prosecutions. So yeah, just like prior years, and really just like the last 5 to 7 years, the DOJ and the SEC have been talking about more individual enforcement actions, and to be sure, in a very small cluster of cases, they can point to some enforcement actions which sort of juice up the numbers. But the fact of the matter is, the vast majority of FCPA enforcement in this new era is corporate enforcement only, notwithstanding the fact that the DOJ rightly acknowledges that corporations cannot act but through real human beings. Now, as to your question, you're absolutely right. Whether it was in September or October of this year, the DOJ told companies that part of cooperation is to basically, gift wrap evidence as to culpable individuals. I don't really see anything new with that. I just think it was spoken by a different person. The fact of the matter is, if the DOJ wants to prosecute more individuals in the FCPA context, I think there's a way to do that. And it's called a compliance defense, because what happens now is there's a gap between the people who know about FCPA violations, the companies and the FCPA Council, and while the DOJ and the SEC encourage voluntary disclosure, there's still this gap. And I think a compliance defense could bridge this gap and give the DOJ and the SEC more evidence as to individuals who are violating the FCPA. So I know your question was not specifically about the compliance defense, but I think the DOJ and the SEC should be in favor of a compliance defense because it will assist them in prosecuting individuals who they say they want to prosecute, individuals who they say will achieve a maximum deterrent effect, but individuals they're not able to prosecute because they don't know the information.
Well, I'm very intrigued that you were able to worm in compliance defense to this conversation, but I've not heard you phrase it, I don't think, along the lines of individual prosecution. So let me think about that one, because if you have raised it, I haven't really thought through it. So
yeah, again, I'll send you the post on that because I used that specific picture.
Right.
It's a bridge. It's a bridge, and I think it could be a very effective bridge.
Yeah. Let me turn now to the FCPA professor himself. You had a couple of, I thought, noteworthy publications in 2014. Obviously, the book, The FCPA in a New Era, which I have said and will continue to say should be the standard treatise on any FCPA, any compliance practitioner, any lawyer, any students, any professor's bookshelf. You continued your scholarly publications, and you also continued your FCPA Institute. And let me start with the book. Can you tell us what the reaction has been, either anecdotally or, if you've got any raw numbers you can talk about? Do you find that practitioners are coming to you with questions or issues you've raised in the book? I certainly found it to be a wonderful resource.
Well, first of all, I thank you for that. And a lot of this is anecdotal. As to numbers, I can't yet retire from the royalties. But anecdotally, the reception to the book has been great. It's written for a broad audience. I think everyone from an in-house counsel to an FCPA lawyer in private practice to a compliance officer to professors, students, and policymakers would find value in it. I think it talks about the FCPA in a more comprehensive, holistic way than it's often talked about. If it's any indication, I gave a book talk in Washington, D.C. in October, and the room was full. I think people want to hear candid and perhaps new ways of talking about the FCPA, since it appears to me in many cases that a lot of people are singing from the same sheet of music. Thanks as well for mentioning my FCPA Institute. This is something I've launched in last summer. I now have 2 institutes under my belt. These are unlike any other FCPA conference I think you will find. It's an intense 2-day learning experience for people who are interested in elevating their FCPA knowledge and skills. Attendance is capped. There are no panels. In other words, 50 to 60 people are not going to be inundating you over 2 days with disjointed information. It's integrated, it's cohesive, there's issue spotting videos, there's skills exercises, and the next FCPA Institute is coming to a town near you, Tom, and that's in Houston on May 4th through the 5th of this spring.
Well, we're definitely looking forward to that in Houston, and we have to get out some more information about that to my viewers and listeners and yours as well. Unfortunately, we're at the end, or nearly at the end, of our time for this episode. But I wanted to ask, do you have any articles in the pipeline that may be coming out in the first half of 2015?
Yeah, I mean, each year I do a year in review article, and I publish that sort of the traditional law professor route, just given how that works for me. So that article will be coming out. I'm speaking in New York City next month at a symposium sponsored by Fordham Law School about corruption, not only FCPA, but domestic corruption. And the article I'm writing for that will be the uncomfortable truth and double standards when it comes to bribery. And I'll be on a panel with former DOJ criminal chief Lanny Brewer at that event. So that should be interesting.
Oh, man.
I'm also doing it in
Mike Tyson versus Buster Douglas, or more the Thriller from Manila?
I'm just calling the spades as I call the spades, and obviously Mr. Brewer is no longer a public official, but was at one time. And then I'm also doing an empirical article which seeks to measure the impact of MPAs and DPAs on FCPA enforcement, because the 10-year anniversary of MPAs and DPAs being brought to the FCPA context kind of passed quietly in December, but we're now at 10 years of this new experiment being brought to the FCPA context, and I'm sort of proposing a way to measure the quality and legitimacy of many of these corporate enforcement actions by using a proxy to measure that.
Well, that sounds very interesting. I very much look forward to that. Mike, if someone wanted to follow up with you on anything that we've said today, could they give you an email or shoot you an email? And if so, how would they do so?
Yeah, I'm at fcpaprofessor@gmail.com, and my website is fcpaprofessor.com.
Well, thanks again. And if anybody happens to be listening to this who doesn't read the FCPA Professor every day, as soon as you finish my blog post, you need to run over and check out the FCPA Professor. So with that, thanks very much, and we look forward to our next visit.
Thanks, Tom.